Between 2008 and 2017, the defendants paid a total of $2,274,035 in cash for the purchase of 25 luxury vehicles. These cars were acquired within the same period of time that the first defendant withdrew large amounts of cash from the official receiver's account at Bank Islam Brunei Darussalam, which were under her control. There are reasonable grounds to suspect that the vehicles are property that can be reasonably believed to be the proceeds of the monies that the first defendant misappropriated. In challenging the prosecutor's application, 3 affidavits were produced in support of the defendants. However, Dato' Setia Davinder Singh SC highlighted that there is no evidence from these affidavits to suggest that any of the properties which were subject matter of the prosecution's application were funded by the family members' financial contributions. The second defendant have also prepared an affidavit in which he relied on the statutory declaration he submitted to the ACB as required from him during the investigations. According to the prosecution, the document does not fully account the source of funding of the bank accounts held under the second defendant's name. Simon Farrell QC objected to the application made by the prosecution as the properties in question have already been seized by the investigators and freezing orders have been issued to the banks to restrict the disposal of the monies. In reply, Dato' Setia Davinder SC stated that the current seizure and freezing orders are different from judicial restraint orders and affords far better protection to the state because any breach of the restraining orders is a criminal offence which can lead to penal consequences. Simon Farrell QC also objected to the restraint over a number of accounts belonging to the defendants and their 2 children on the basis that the monies held in those accounts were from their salaries and allowances. The prosecution reiterated what the ACB investigating officer has said in her affidavit in respect of these bank accounts. Her financial investigations reveal that cash deposits were made into those accounts, some of which were made several days after the first defendant made large withdrawals from the OR accounts. This shows that the monies have commingled and therefore have become tainted properties under the law and are to be regarded as proceeds of crime. The second application made by the prosecution was for the defendants to pay prosecution costs as provided for under the Criminal Procedure Code. The prosecution sought for the first defendant to pay prosecution costs of $1 million and the second defendant to pay prosecution costs of $500,000. The sums represent 65% of the actual costs incurred by the prosecution, comprising professional fees of foreign counsel and other related disbursements and costs incurred in relation to the investigations against the defendants, including storage and maintenance fees and insurance coverage for vehicles seized from the defendants. Simon Farrell QC objected to prosecution's application for costs as the defendants do not have any means to pay. Additionally, he stated that the cost sought against the second defendant was high, as he was only convicted of 6 money laundering charges. Dato' Setia Davinder Singh SC reminded the court that out of the $15.75 million misappropriated by the first defendant, $6 million still remains unaccounted for. It would not be right to allow the defendants to say they have no means if they withhold information in relation to the whereabouts of the monies unaccounted for. He added that the second defendant was complicit in enjoying the benefits from the misappropriation carried out by the first defendant. It is far-fetched to suggest that if the whereabouts of the $6 million is known to the first defendant, she kept it a secret from her husband. He further emphasized that the state has had to carry the burden of considerable costs to prove the defendant's conduct and ensure that justice was carried out. The defendants must bear responsibility for the state's burden. The final application made by the prosecution was to lift the stay of the charges under Section 12(1)(b) of the Prevention of Corruption Act against the defendants for having it in their possession properties which were disproportionate to their emoluments. The stay was ordered by Justice Luga Mawson in October 2019 after the prosecution closed its case. The defense objected to the application on the grounds that it should only be heard in the Court of Appeal after the appeals against the defendants' convictions are decided. Justice Gareth Luga Mawson will deliver his decisions on the 3 applications made by the prosecution tomorrow at 2 in the afternoon.